I guess we have a recording in progress. So it's been a while since we've talked about anything, so I hope everybody had a good vacation, a day off, and now we get to start over again, since usually I forget everything that missing week. So from now on, I think, other than the break at Thanksgiving, no more days off. So, but on the other side of that, I think we're almost 25% of the way into the semester already.
Oh my fucking God.
That's what I said. So time flies when you're having fun. But so we're going to talk tonight a little bit about NEPA, CEQA, and zoning. I mentioned before that California, we have the California Environmental Quality Act, which is kind of a baby national environmental protection act follow on. So all of this started back in the late 60s, early 70s. NEPA, which is the national policy, was signed into law, I believe, in 69 by Richard Nixon. And then in 1970, California had their own that was signed into law by Reagan. So almost all those, as far as I know, all the states have a baby NEPA. And before you do anything of significance anymore, you have to go through some sort of environmental review. And so I do have a presentation on that. And we will look at that. We'll also look at hopefully some zoning tonight. And then we're going to start getting into the building codes themselves. All we can do is scratch the surface on zoning. Every city, every county has a different zoning ordinance. It's part of the municipal code or part of the county code. And so it does have the force of law. There's lots and lots of lawsuits that come from this. Whenever a major project starts up, there are also a lot of legal challenges typically to the validity of the environmental review process. So let me take a look here. Share my screen. Anyone have any questions though, before we get going? Okay, hearing none, I shall proceed. But if you do have questions, feel free. Oh, I know what I forgot. So this looks a little bit like a Mesa shirt, but I think it's a Michigan shirt. But we'll just say it stands for Mesa. I didn't go to Michigan, but one of my daughters is a Michigan grad. So, but let's take a look. Hopefully you can see this planning commissioner workshop.
Yes.
Yeah,
Yes.
so CEQA 101, CEQA 101. So I will post this in the Canvas. I will post this in Canvas. So this was put on by a couple of consultants a few years ago, still pretty valid. So I don't know of any significant changes. So CEQA is the California Environmental Quality Act. And so we have a little introduction. So we'll be talking about a whole bunch of acronyms, and I think I will post this too. This is from the Bureau of Ocean Energy Management. Hopefully you can see this fact sheet, correct?
Yes.
Okay, good.
Yes.
So you may not be able to read it, particularly if you're on a phone, the screens are too small, but I will post this into Canvas. And there are one of lots and lots of acronyms. And one of the problems I have in life are acronyms, because there's lots and lots of them, and I can never remember exactly what they are, because for a lot of different industries, you may have the same acronym that means something completely different. But anyway, this one seems to be reasonably complete. And quite often, if you have a project, a lot of these other players become involved, like the Department of the Interior, or Fish and Wildlife people, or so there's all kinds of terms here. NOI is a very common one that you will hear about, notice of intent. That applies to a lot of different regulations. And we will be talking in particular about things like EAs or EIRs or EIS, environmental impact statements or environmental impact reports. So in California, we have environmental impact reports. And in the federal law, NEPA, they refer to those reports as environmental impact statements. But I digress. That's just the acronym. So I will post those, and feel free to stop me at any time. But this costs a lot of money to have this done. It requires a bunch of professionals. If you're interested in getting into this line of work, generally you have to go take some classes somewhere. And again, it's been around since around 1970, and they have been expanding it. So the most recent component for environmental impact studies, or the California Environmental Quality Act, is equity and social justice considerations, where you have to make sure that the poor and the people of color and other marginalized folks have not been overlooked in the process. So the Federal Highway Administration under NEPA recently stopped a great big freeway project through the city of Houston, because it disproportionately impacts a poor neighborhood. They're going to take about 1,000 buildings, and so the Federal Highway Administration stopped the project. So this is something that's probably taken several years to design, several $1 million to design. Construction had already started. People were complaining, lawsuits were flying, and FHWA has stepped in and said this does not appear to have had appropriate review from the standpoint of equity and social justice. And while that has been a term I've only been hearing about in the last couple of years, to any great degree, it does go back to 1994. So that's when the presidential executive order was signed and put into effect. So EIR is the shorthand for Environmental Impact Report. CEQA, as I said, is California Environmental Quality Act. Here's a little bit of the history. And again, I will post this in Canvas, so you don't have to take a lot of notes. If you don't remember what Richard Nixon looks like, there's a picture of him on the right, but 1969 National Environmental Policy Act. So, and for some reason, I can never remember that one exactly as it is. 1970 though, California Environmental Quality Act. And so one is federal law and applies to federal agencies. When they're planning on doing something, they have to go through NEPA. Now, there are some projects here in the state of California and locally that have to go through both NEPA and CEQA. So for bridge projects here in San Diego County, for example, many of those bridge projects, even if they're initiated by the city or county, have federal money that gets contributed. And if the federal government is contributing money, you have to satisfy the requirements of both NEPA and then CEQA, the California Environmental Quality Act. So, and it can be a bit pricey. For example,
when creating arrays in SketchUp, you can play with the number of copies made. Select several of these columns and copy them once, then type 3x and press enter. This isn't enough. Type 8x and press enter. This is too many.
Susan,
okay, well, I turn that off, excuse me. Leave that little button up there. So, where was that? Oh, yes. So sometimes you may have to comply with both, but I think we did a bridge project up in Rancho Santa Fe, for example, and the bridge itself, we spent $2.5 million on. The mitigation for CEQA that we spent was also $2.5 million. So the environmental costs, construction costs were just as much. That does not include the reports and the public review time and all of the additional design that went into the project. So, you know, these meeting CEQA objectives or requirements does have significant monetary costs as well. But the objectives is we want to provide the public and decision makers with information about significant environmental impacts of a proposed project. And you're supposed to look at near-term and long-term. And if this, your project is part of some ongoing development, then you're supposed to look at the effect of the entire string of developments as well as just the individual project you're looking at. So if there are impacts, then normally what we're trying to do is identify ways to avoid or reduce significant impacts. And there's a fairly big laundry list of potential impacts that we will, I think, touch upon. And in some cases, one of the considerations you're supposed to make is that you don't do the project at all. If it looks like you're going to have such a large impact that you can't really address mitigation means, then one of the options is drop it entirely and go put your money somewhere else, because in most cases, you know, there are certain outcomes that the act won't tolerate. So we're also supposed to look at feasible alternatives and mitigation. This is a living document, so it does change a little bit over time, just as our concern about the environment changes over time. New information becomes available. People start to see the impact that they hadn't anticipated from other projects, and then there's some means of moving that into the review arena. This is supposed to be an open and transparent process. And so one of the things that happens is you're required to disclose to the public the reasons the project is approved, even if it's going to have some significant impacts. And there was a big lawsuit up north somewhere. I forget what city it was, but they condemned an old neighborhood. They had an old rundown neighborhood, and they wanted to put in a bunch of new development so they could collect more property taxes from it. And so supposedly in the public interest, they went in and basically told all these people that they were going to take their property and they were going to have to move. And, the court actually upheld that taking and made a decision that it was in the public interest. Now, the people that were being displaced, a lot of them were not too happy. So if you go through a condemnation where the government comes in and takes your property, which it can do in certain circumstances, they're required to pay you market value. So there's always a big fight over what that market value is. But some things that don't have a specific market value, or there may be very personal feelings that I've been kicked out for no good reason. Somebody else can make more money, and that may not satisfy everybody. So anyway, so what we're trying to do is protect the environment. And one of the things that got NEPA going is, during the late 60s, early 70s, we were noticing lots of environmental problems. In particular, there was a river in Ohio, I believe it was, called the Cuyahoga River, and it burst into flame on 5 or 6 different occasions. And industry was pouring toxic materials into the rivers and into the ocean. They had a problem in Japan, place called Minamata. It was near a chemical plant, and people were suffering from mercury poisoning. And so a lot of this information was documented, and it was a period of a lot of social unrest and people wanting a change. And so while you hear a lot of that right now, it was, I think, much more active and in the forefront. There were a lot of pushing the political envelope, the social envelope during the late 60s and through the 70s in particular, that were probably much more dramatic than what you see going on today. People are reasonably more polite now. But anyway, CEQA's objective: protect the environment. You want to make decisions thinking about the environment and having some idea of what the long-term consequences are going to be. So CEQA does not require that projects with significant impacts be denied. If a city or county finds economic, social, or other conditions justify it, then you can go ahead. You say, okay, well, yeah, we're going to have some bad things happen to the environment. However, we're looking at certain benefits that we feel will offset that cost or that damage. So few of these acronyms are within this document, but this is a much shorter acronym list. NOE, Notice of Exemption; NOP, Notice of Preparation; IS, Initial Study. So the big ones you'll hear about are ND, Negative Declaration. So that's the best from a developer's or project initiator's standpoint. You can either have a categorical exemption, or in NEPA, they call it an exclusion, which means you're not subject to NEPA or CEQA. Or you can have a ND, a negative declaration, and you can say, yeah, our project is so small and that there's not going to be a harm to the environment. And in some cases, you may claim that your project is going to, in some way, provide a positive benefit. But generally speaking, you start developing things, the natural environment's going to suffer a bit. So mitigated negative declaration, notice of intent. And so most of these things require public review and public notice, where you're required to put the public on notice. There are a lot of different environmental groups in California. Anybody belong to an environmental group? Sierra Club? Yay, nay? Clean
Nope,
Ocean,
not I.
Clean Ocean Action? Any of the local environmental conservancies? So there's lots and lots of these groups around the state. Many of them are headed up by attorneys. And for the most part, I'm in favor of trying to save the environment. If you live in San Diego, most of you are too young to know. But the air is certainly much cleaner in San Diego than it was 30 years ago. Ocean, I'm not so sure about. We still, after every major rain, typically they'll close some beaches down. That's usually because of bacteria count. We still have a problem with the sewage that comes up from Mexico. One of these days, I guess they'll actually really fix that, but they're still talking about it. So there are EIRs, environmental impact reports. DEIR is just a draft. There'll be a final. Usually once you come up with an environmental impact report and have determined what kinds of mitigation is required, that as a condition of issuing a permit or allowing a project to go forward, you have to have a MMRP, that's a mitigation, monitoring, and reporting program. So yeah, this is what we said we were going to do to make things better. And then you have people out there to document that whatever was required was done. And when you're finished with that, you have to have a report that's available for the public to review and inspect. So happy days. So if you're interested, you can look into the Public Resources Code. The sections 21,000 through 21,178. The guidelines, remember, this went into, was adopted in 1970, and the guidelines were first issued in 1973. So there's a California Code of Regulations, Title 14, if you want to look into that. And it was developed by the Office of Planning and Research. It says here this was last updated in 2010. There may be something slightly more recent. I'll have to look and see. And then we have the courts. So many of these things wind up in court, and the court may rule on whether or not an EIR actually met the criteria that the state has established, or whether it needs to be sent back for additional work or additional review. So this is one of the things we look at is air quality, certainly. So if you were going to build a church, for example, one of the things you typically have to do is look at traffic, look at air quality, and whether or not that's going to be a factor. You know, every project typically generates additional traffic, additional trips. How some of that is going to change over time, I'm not quite sure, because in terms of air quality, we're switching over to electric. If we go all electric, we may be looking at completely different issues. So I don't know if anybody's been following the fusion powers. So we have fission, that's what the current nuclear power plants use, but the sun is a fusion power plant, and they think they're getting closer to coming up with a method of generating energy more closely aligned with what happens in the sun. So we'll see. They've been talking about that for a long time, but I understand they've made some breakthroughs. And then you've got all these other local and regional agencies that may have to weigh in that have a piece of the CEQA oversight. So here in San Diego, we have in San Diego County more endangered species of animals and plants than any other county in the United States, which is always hard for me to believe when I go visit my sister in Washington, because they seem to have much, much more variety and density of plants and animals up there than we do here. However, San Diego County has more endangered species than any other county in the US. So anybody here heard of a vernal pool?
Yes.
Oh, yeah.
Okay.
Yes.
And so those are just depressions. They're called vernal pools because most places in the spring or in the vernal season is when you get your rain and these depressions fill with water. And there are little tiny animals that live in the dried earth from these pools. And when they fill with water, the little animals come out and wiggle around. And then as the pool dries up, they go back into hibernation. But if you disturb one of those without a permit, you can get into some pretty big trouble. So I believe there's fairy shrimp, ghost shrimp, and some other little critters that live in those things. So we also have, like I said, a number of endangered birds. You may have noticed along some of the road projects or freeway projects, when they start, they put up these great big plywood walls. So those are typically sound walls so that the nesting birds are not disturbed by the construction. Arroyo toads, anybody heard of the arroyo toad? Yay, nay?
I have not.
You haven't? Let's see. Well, we've got them here and they're endangered. So hopefully you can see the picture on the right. Yes.
Yep.
Okay.
Yes.
Yeah, yeah.
These are arroyo toads. They're an endangered species. And when we build bridges here in San Diego County, quite often we have to go look for them and then make sure that if they need to move, they can move. So this little map in the upper left, you can see about a little over a half of San Diego County is home to these guys, but that is one of our endangered species. I'll see if I can find the whole list and post that too, but and somebody asked me what they taste like, but I've never eaten one. And they're actually pretty small. So it's but before we do a bridge project, we usually have to send a biologist out to do a biological survey, and this is one of the things that they're out looking for. So, anybody here been to Legoland?
Oh,
Yes.
yeah.
Okay, well, Legoland, when they were getting ready to build that, Legoland had to go through CEQA, and there were some people in the area that did not want to see that development go in. And so a couple days before the biologists were scheduled to go out there and do their biologic survey, somebody had gone out, had captured a bunch of endangered animals, species, had caged them up, and were getting ready to release them on the site just before the biological survey was going to be done. And so I think the sheriff's department got wind of it and actually went out there and caught the people, or at least found the cages with the endangered species still in them. And that I think probably saved them a little bit of trouble, because their environmental impact report might have looked a lot different if those animals had been released and counted in the survey.
That's crazy.
Well, it may be crazy, but that's the sort of stuff that happens. Because there's always people that want to move forward, and there's always people that don't want things to change at all. But those things do happen, so. So anyway, this is just a little slide. Generally, for any project, there's a lead agency. That's usually the one that things get initially submitted to, or that has to be identified through CEQA. So you have agencies with jurisdiction by law. You have concerned citizens and organizations that normally, as part of the process, you have to say, hey, we're getting ready to do this project. Documents with regards to the project scope and plans are available these days, generally over the internet. You can take a look at them. And then if you have any concerns or issues, you can weigh in. So we have a whole bunch of different environmental consultants. And if a developer, for example, hires a consultant, in most cases, they go out and hire consultants that are going to provide them with information that they would like to hear. And then quite often they will be arguing with the government agencies over their conclusions. Because like I said, if someone's paying you to do a report for their project, chances of them getting paid are not very good if they come back with a report that says, gee, this project shouldn't go forward. So lots and lots of discussions over these things. So, so. And so we got regulators, and we got all kinds of different layers of regulators, because, we have federal, we have state, we have local. They all have some say in all of this. The regional water quality control boards have a lot of input with many of the projects. Environmental Protection Agency, and while there is a federal EPA, California has its own Environmental Protection Agency. Office of Planning and Research, Department of Fish and Game. And, I have some friends that are fishermen, trout fishermen, and they do not like the Department of Fish and Game very well, because they have told me on a number of occasions that they feel the Department of Fish and Game would only be happy if there was no fishing and there was no hunting. And yet their purpose is a little bit different. So, but we've got, depending on where your project is located, they may get involved. If you're doing work on a navigable river, for example, then the Army Corps of Engineers gets involved. So it depends on which agencies have jurisdictions over which part of your project. The Air Quality Control Board is also very active in reviewing these reports. So the participants, you got your project sponsors, both public and private, environmental and resource advocates. And there are lots and lots of different environmental and resource advocates here locally. Private property, commercial, and labor groups. So a lot of times, labor groups may be lobbying for something because they want to see more jobs available. You have local interested parties, and you have individuals. So, worked on a small culvert project up in North County. The county had the permits, had gone through environmental review, and they started in on this culvert project. And they encountered some groundwater during the construction of the culvert, which shouldn't surprise anybody. It was in a drainage channel. But they started to pump some water out of the ground and dump it downstream of the culvert. And the property owners that were next to the project weren't happy with the project, and they called the Water Quality Control Board, and the Water Quality Control Board stopped the project, and it was held up for about a year, and the price went from about $250,000 to about $500,000. It eventually was built, but the basis of it being stopped were environmental concerns. So stuff happens. So yeah, there's Sierra Club is one of the more active ones. Save the Bay, I'm not familiar with. California Native Plant Society, BIA. So that's one of the labor or industry groups, Building Industry Association. NAHB, National Association of Home Builder. So, and I don't know who CBE is, but I'll find out. So, so typically in terms of the review, you'll have a lead agency, you have a responsible agency, the group that gets assigned for being responsible for the whole thing, trustees, and there may be a federal agency involved too. So there's a bunch of documents. Normally, if you can come up and say, hey, this is an exempt project, so certain types of projects are exempt or are not considered projects. And we'll get to that here in a minute. But, this is primarily the reason for the parcel map process, for example, is prior to 1973, you could own a piece of property. You could, on a piece of 8.5 by 11 paper, draw up how you were going to subdivide it, submit it, pay a fee of $30, and in 30 days, you would have a what was called a lot split, which is similar to today's parcel map. Now, today, you can't do that. You have to go through the parcel map process. You have to file a tentative map. Generally, you're going to spend thousands of dollars, and I believe you have up to 5 years with the possibility of an extension to take care of all of the environmental issues and other requirements under the Subdivision Map Act. And so that's where our requirement, Subdivision Map Act, where the state of California said, if you're an agency overseeing the subdivision of land, you have to have a general plan And it's also about the time we got all the rules for CEQA. And so it's big business and will continue to be so. So the agencies, okay, can obtain information from anyone. And so you're going to have, may hire consultants on both sides. The agency may hire consultants to do this work. And then there are outside consultants for representing other people that may be pulled into this. But there's a documentation chain that you're going to have to deal with. So the process, there's some key milestones here. Action is proposed. And I think there's a flow chart in here. You have to decide if the proposed action is a project or not. So if you're going to do a subdivision, that's a project. If you're going to re-roof a house, that's not considered a project. The house is there, the roof was there. All you're going to do is trade one out for another. You still have to meet the building code requirements, but per CEQA, that is categorically exempt because it's not a project. Now, if it is a project and you're subject to CEQA, that's going to send you down one path. And if the project is exempt and everybody agrees that it's exempt, then you can just go start your project. You may have to get some permits, but you don't have to go through the CEQA review. If your project is not exempt from CEQA, you have to prepare an initial study. So that study is reviewed, and you have to create an environmental document. You have to prepare it in a specific format typically. It then goes to public review. So you have to notify, in particular, people that are close by, but there's also a website that you can go to for a lot of these things. And the public is given usually 30 days, 60 days, 90 days. It depends on what it is to review the document. If they have comments or concerns about the environmental review, then those are usually incorporated into a final document. So generally we have a draft environmental document, and then once the comments are looked at and dealt with, there'll be a final document. The public still gets invited to see what's going on. That EIR gets certified eventually, and then you're going to adopt some sort of a program typically to mitigate the environmental impacts that have been identified. And just because you have a environmental impact report doesn't mean that it won't be challenged. It doesn't mean that it's covered everything that it should have. It just means that at some point it's been blessed, and generally speaking, the thing will move forward until or unless someone or some group files a lawsuit or a court steps in and says, hey, we think there's something wrong here, in which case the process may have to back up. So eventually you get a notice of determination. So if you want to do any kind of discretionary permit, normally you're going to have to go make an application. And I'm trying to keep this short, but it's a little bit more involved. But if you want to do something, Generally, you'll go in, you'll talk to, if it's in the city of San Diego or county of San Diego, talk to the planning folks, have some sort of pre-application consultation. You may hire land use attorneys or professional planners to do the initial investigation and kind of see what they think will fly. Then there'll be a pre-application consultation. Based on that, there'll be an application submittal. And so what a lot of people want to know is, will my project be approved if I pay you all this money that you're asking for? And so what they'll normally be told is, if you don't pay the money, you have no chance. So if you do pay the money, you're never quite sure where your project is going to wind up, if it's going through a discretionary permit review. So we make a determination that the project is or is not subject to CEQA. And part of that is reviewing for exemptions. There are what are called categorical exemptions, where there's a list of things that you can do in terms of new construction, for example, that you don't need CEQA review for. There's a much larger list, though, of things you do need review for. So there's a flow chart in here. Again, I will post this to Canvas. There's a better flow chart here somewhere. This is the action discretionary project. So that's kind of a yes or no. Is the project exempt? Yes or no? Is there a possibility that the project may have a significant impact? Yes or no? And then what is the appropriate document, or what form should that environmental impact report take? So a little bit depends on what the those impacts, environmental impacts are, and what they are not. So, you know, are you concerned about water quality? Are you concerned about air quality? Are you concerned about preserving archaeological relics? Do we have paleontological resources? Are we trying to protect plants, animals, both? We have some unique geology that we're trying to preserve. So there's a whole long list of things that we're looking at. And in some places, they're just worried about visual impacts. You know, are people going to like the look of what happens when it's changed, or are they going to be upset? And some of these things are very subjective in my mind. And over time, you know, the concept of what society wants or what society thinks is okay or not okay will also change. All right. So the preliminary review, any questions?
Yeah, Larry.
Yes?
I'm just curious as to if you can maybe tell us what the difference between a discretionary permit review and like a CUP, or a major use permit or a minor use permit.
Yeah, all of those things are going to require, those are discretionary permits. So somewhere I think I've got that in here, but the short of it is, for a building permit is normally for a run-of-the-mill project, is normally what's called a ministerial permit. And those are typically categorically exempt from an environmental review. So if you have a piece of property that is zoned for a residence and you want to make an addition to it, right, you're going to do a permitted use. You're going to obey the setbacks. You're not going to exceed the floor area ratio or the allowable height or any of those things. So the established zoning requirements you can comply with. and your plans meet building code requirements, then usually the jurisdiction has to give you a permit. And so then that is exempt, categorically exempt, or under NEPA, it's categorically excluded from environmental review. If you want to get a permit to re-roof your house, that's also something of that nature would be exempt. Now, conditional use permit, that's a little different. So many times they'll say by right, you can, in a single family zone, you can put in your, you can build a residence or you can add on to it. But if you wanted to have a home office, in some cases, a home office, you would be allowed to do that, but you would have to get some sort of use permit. And once you have to get a use permit, then that no longer falls under ministerial. Those are discretionary permits. And you're going to be subject to some form of environmental review under CEQA. So major use permit, that is even bigger. So some of these require, full public review, and some have a more limited public review if it's considered to be relatively minor deviation. But subdivision, land development of any size, you're going to build a big box store. Again, that's going to go through a discretionary review. That would be subject to CEQA. If you have an existing building that's looking for a tenant, right? You just want to move into a tenant space, then that's normally exempt from CEQA, because usually, again, if you can meet zoning requirements and the parking requirements, they pretty much have to give you a permit. So those are categorically exempt, whereas and that's a ministerial permit versus some type of review process where you're never quite sure what you're going to have to do. Those are subject to CEQA. So I don't know if that answered your question.
Yes, thank you. Yes, I actually had a piece of property in Ramona, and that one I was going to build a house on, and it was a pretty large lot. It was like a 7-acre lot, and it had portion of the lot that wasn't buildable or couldn't be disturbed because there was some artifacts that were found there.
Okay, so they're probably a geologic open space easement or something. Or
Yeah, it was an open space
archaeological,
easement.
excuse me.
And yeah, and then the vernal pool thing came up. Luckily I didn't have any, but we did have to do an environmental impact report for that property.
Right.
So thank you.
Okay. So anyway,
Larry,
yes.
I have another question regarding exempt projects, but for bigger projects, maybe it is under NEPA, but if we are thinking about border wall, what's happening for this one? Is it under National Security Act or something
Yeah,
different?
border wall, they still have to do it's still going to be subject to NEPA.
Okay, right. And do we have initial study? Because if we are thinking about endangered species, it's gonna be impacting on many species traveling between two countries.
Yeah, they should be.
I think.
Let me see, just 1 second. Well, take a look.
Thank you.
Yeah, there's a yeah, I know there's some reports out there. And if you want a second, let me stop this. And I just pulled up another document.
Thank you.
And so what we have right here is a paper. If you want, I can send it to you. This is environmental impacts of the border wall between Texas and Mexico. And so this is, I guess, from the University of Texas Law School, but the intro here talks about, you know, the United States government asserts that construction of the border wall between Texas and Mexico would affect wildlife and aquatic resources by conferring only short and long-term negligible to moderate adverse and minor beneficial impacts. And so this particular paper is challenging that assertion. But in order to build that wall, the federal government does have to go through NEPA and make some findings. Now, it could be what they might say, and I haven't seen the paper, so I don't know, is they might say, yes, we're going to have some environmental impacts, but the problem of national security outweighs these negative impacts, and we think that we should go forward anyway. And I know that there are going to be detractors, but again, the whichever agency of the federal government was pushing it, and right now I think the border walls are kind of on the back burner. They did construct some more, but they have to go through this. So if you're interested, I can copy this and send it to you.
Thank you so much. Yes, please.
Okay, let me see if I can. At least get the link for it, and copy it. Oh, there it is. Okay,
So Larry,
yes,
so in this case, the White House has the authority over the border construction?
no, they don't have final authority. They still have to obey the law. But they can fast track things, or in some cases, as I said, they might say that national security is at stake. And they've got to push these things through. Some of these studies have been done a long time ago. You know, the problems at the border are not new, but how quickly they can push those through. You know, they can try and accelerate the process a little bit, and in some case, I think under executive order, they can suspend some of that stuff, but then there's legal challenges that will go on for a long time, and eventually they might come back and say, okay, you got to tear the wall down. So just like they do, you know, along the Mississippi or down in Florida in the Everglades, where they say, okay, the Corps of Engineers came in and did all this work, and they had environmental impact reports for it, but we've decided that those reports, based on the results, those reports were flawed, and people start filing lawsuits, and then the courts may order the government to undo what they've already done. So anyway, this particular one, I'll put this particular one into Canvas. And if you want to look at it, you can. It's not going to be mandatory, but you know, everything, all of these things that are done. Now, of course, there are certain things going on that in the interest of national security, supposedly, we never find out about until much later. So, building one of these big facilities to intercept all your cell phone calls, for example, that should have had an environmental impact, but if it's done under, NSA or some similar agency, sometimes that they're so top secret that nobody knows what's going on. And there are some ways to circumvent NEPA, but they require some pretty high level input. And I'm not the legal expert on all of that. I just know that, whenever the government, the basic law is that the government wants to do something, they have to consider the consequences to the environment. And if private citizens want to do something, they also need to consider the impact on the environment. There are some exemptions, like those categorical exemptions or exclusions. So some things, it's if you had to do an environmental impact for every room addition, for example, well, that would make housing even more expensive. And to a lot of people, they would say, well, you've already let them build a house, as long as they're not violating zoning. We don't think that's really a significant impact. So I guess the law could change. So what time is it? Oh, okay. We'll take a break here pretty quick. Where was I? So this little picture right here, we got a little preliminary review, the process. So on the far left, that big red arrow that's sticking up in the air, that goes from low risk to high risk on the vertical axis. Going out to the right, this big blue arrow on the bottom, this is the time needed to complete the CEQA process. And so you can see that this yellow, these are the categorical exemptions. And they typically take 1 to 2 months to process those for this. And I think it's going to vary with jurisdiction. And right now with COVID, everything seems to take forever. If you're going for a negative deck, that's what this little green hump is. And you can see the green is only about half of what this long light blue little area is. And so here they're talking about 4 to 9 months for a negative declaration. And here we're talking about 9 to 18 months for a environmental impact report. And again, we're talking about the preliminary review or to go through the CEQA process. This doesn't include how you're going to fix it or how you're going to implement the means and monitoring and final report into your project schedule. So some of these EIRs for major projects cost millions of dollars. Millions of dollars. And some of these things take years because of the environmental, because of the legal challenges to these things. So now this is just general, but you can see if you want to build a shopping center, for example, you've got to do an EIR, you want to do a subdivision, in 18 months, things can change dramatically in terms of, what the marketplace is if you're proposing to do something new. So there's a lot of risk associated with dragging these things out, plus costs can go way, way up. I don't know when the lumber prices are going to go back down. So, and here's a little bit of a flow chart. You know, action proposed. So here in the upper left, and again, if you've got a small screen, you're not going to be able to see this, but I will post this in the Canvas. So this far upper left, action is proposed. So it's either not a project or it is a project. If it's not a project, you have no further action required under CEQA. You're done. If it is a project, we mentioned the two types of permits, ministerial or discretionary. So ministerial, you know what the hoops are you have to jump through. And if you jump through those hoops, then you get your permit and there's no further CEQA action. So that's your typical, you know, I own a residential lot, I want to build a house on it. It's already zoned. Supposedly, when the subdivision is planned, it has to go through a CEQA review. And the cumulative impacts of all of the houses that go into that subdivision have been looked at. But if they decide to sell the lots off individually, you know, people are allowed to develop those, and as long as they meet the zoning requirements, you know, building type, use, height, size, setbacks, then they get a permit. So that's a ministerial project. If it's in there for discretionary review, I want to put a church in a residential neighborhood. I want to build a gas station in a residential neighborhood. Then those typically need to go through a discretionary review because they're not permitted by right, but they are permitted under some type of use permit. Could be major, could be minor. The other option would be to do a rezone, but generally a rezone is, again, it requires a discretionary review and you have to go through CEQA for a rezone. So that's what all this stuff is. You know, it's a discretionary project. Some discretionary projects are still exempt from CEQA. But if they're not exempt, then you have to prepare an initial study. And your initial study is going to say, you know, if you paid somebody enough money, then they may say, yeah, there's no impact. And if you can sell that to the public and to the people reviewing, then you get a negative declaration and you're pretty much done. However, the more typical thing is you're going to find some potential impacts to the environment. And then you got to come up with how are you going to mitigate it, or do the benefits of the project outweigh mitigating, et cetera, et cetera. And so down here in the far lower right, they say prepare an EIR. And so that's where you're going to do your environmental impact report, or under NEPA, I believe they call it an environmental impact study. Simple. So project, what is a project? And so again, this is the PRC is the Public Resources Code. If you want to look up this section in the Public Resources Code, that's one of the, I think 29 different California codes that make up the laws of California. But the definition is an activity which may cause either direct physical change in the environment or a reasonably foreseeable indirect physical change in the environment. And so down here, what we've already talked about is If it's a project under this definition, it requires agency discretionary versus ministerial approval. So we have those ministerial permits and we have discretionary permits. And when they talk about discretionary, it's not your discretion. It's generally the government's discretion. And so they give you a definition. And again, this comes from the Public Resources Code. Discretionary project means, says a project which requires the exercise of judgment or deliberation when the public agency or body decides to approve or disapprove a particular activity. How many people here are in complete agreement with what the government does?
I mean,
Probably 0.
Probably 0. And again, we have all these regulations and yet very few people are actually involved in them. But it says the exercise of judgment or deliberation when the public agency or body decides to approve or disapprove a particular activity as distinguished from situations where the public agency or body merely has to determine whether there has been conformity with the applicable statutes, ordinances, or regulation. So the ministerial permits, they've already established, these are the hoops you jump through, and if you jump through these hoops, you get a permit. And the discretionary permits are those, well, you tell us what you want to do, and we're going to have to figure out which hoops you need to jump through. And once we figure out which hoops you have to jump through, then we're going to see if you can jump through. And we're not going to guarantee that that's going to do it. You may have to do something else. And so that's why it's so scary when you have to go discretionary versus ministerial. Yeah. So ministerial, they give you a definition. They're basically saying a project which requires a decision where all the rules are known beforehand and there's little or no personal judgment by a public official as to the wisdom or manner of carrying out the project. And they say, again, right there, conforming with applicable zoning and building codes and paying fees. So they'll let you pay fees as much as you want. So generally speaking, regular building permits are ministerial. However, when it comes to discretionary land use, where you're asking to do something a little different than what the zoning ordinance allows, or you're subdividing land, or you're doing a great big project, those fall under discretionary permits.
Hey, Larry, I have a little discretionary story or permit story.
Okay.
So I was involved in the Sierra Mesa Planning Committee. So you guys are familiar with that huge development off of on Friar Road, Costa Vida. Like it is the single largest PUD in San Diego recent history, like in the last, I would say, last 20 years. So there are over 4,000 housing units being built.
So those are the ones off of Friars Road, right?
Yeah, it used to be Quarry Falls, like, so where it used to be that big quarry along Friars Road,
Yeah.
Eventually you're going to see close to 5,000 housing units.
Right.
Right. So we had been fighting with those guys and with the city from putting a connecting bridge to from below the quarry, what used to be the quarry, up into our neighborhood, up in the hills, off of Phyllis Place or Murray Ridge.
Right.
And that bridge was not part of the original plan.
Mhm.
And the committee or the people who live down in that development, they don't want it, and neither do we. So the city involved all the firefighters saying that, oh, this is necessary for accessing the neighborhood in case of emergency, for ingress and egress of residents, and all those things. And
Yeah, public safety.
public safety, exactly. And we've been fighting them for 4 years.
Yep.
And so nothing has been done naturally. And we have all of those things that you just discussed about discretionary and ministerial and EIRs and dueling EIR reports and challenging each other's EIRs and all of those things. Traffic controls or traffic studies, all of those things. So that's it. It is, needless to say, a very expensive process.
Yeah, well, expensive and time consuming. So I know projects that have been held up for basically 20 years while they go back and forth over the project and the initial scope, and then they look at the impacts, and then they decide they can't afford it, and so they redesign the project, and then every time you redesign the project, you may have to go back and do a completely different review because the scope of the impact will change. So that process can take a long time. And you know, if you're a consultant, it's pretty good work. So, anyway, let me just cover this and then I'll give you a break. But ministerial versus discretionary projects. So tentative maps, if you're dividing land in California, that is subject to a discretionary permit, and you file a tentative map, you file a final map, but part of the tentative map process is the environmental review. If you're doing a general plan, which is how you're proposing development occur in a city or county over a projected typically 30-year period, that is subject to CEQA review. Conditional use permits, which I think Amber was talking about, and so there are different types. There are major and minor, and they may have some slightly different names, but they also require CEQA review. And then things, ministerial projects, if you want a driver's license, right, you got to take a test. You pretty much know what the requirements are, and if you pass them, they got to give you a license. You want a demolition permit to take something down, in most cases, that's just a ministerial permit also. However, in some cases, you know, it may require some sort of a review because you may be dealing with a historical designation on a structure or some part of the built environment. And then building permits. So generally simple building permits related to uses that are allowed by right on a property are typically exempt from CEQA review. And they're what they refer to as just ministerial projects. There's not much judgment or opinion. You just have to show that you comply with the criteria for issuance. So well, I think we already talked about this. So if you have a project, right? You want to build 50 new homes or a new big box shopping center, that would be a project. But if you want to install a roof or have a lease for a big box use in an existing building, normally that is exempt. Now, what will sometimes happen is somebody will be trying to get a permit, and you may have an attorney or a group or person file a suit against the agency that is going to grant the permit and say, wait a minute, we don't think that's exempt. We think it's a project. And then once somebody files, some type of lawsuit, you normally have to respond to it if you hope to prevail. Anyway, I think we will give you a short breaks. So I'll give you about a 10-15 minute break. You can run around, wake up, go have a beer, whatever you want to do. And then we will come back and look at these statutory exemptions. So, because those are the things that have been exempted anyway. How'd that thing go? Oh yeah, over there. Anyway. So I'm going to go get a drink of water. I'm going to turn off my video. If you have any questions, you have a project that you need to talk about, we can talk about it. But I'll see you back at 8:15. So I'll be right back.
Amber, I have a question for you.
Okay.
Do you know if we're having class on Wednesday? Or
You
if
know-
he's not showing up?
I haven't heard from him. I sent him an email last week and there's been no response. I'm a little bit nervous because I don't want them to cancel the class. I need the class to graduate, you know?
Yeah, I'm with you. That's why I'm asking you. And since you talk to him like most of the time, that's why I was wondering.
Oh yeah, he's been pretty silent. I haven't heard anything. I was hoping we'd get something like, oh, hey, I'm sorry guys. But yeah, so I guess we'll just have to wait until Wednesday and see.
Larry can teach the class, I think.
Hopefully.
I know. I was wondering if, I was talking to my husband about it. He said you should contact like the chair or the dean just to tell him that, we've missed so many classes and to see if hopefully they won't cancel it or if they are going to assign a different professor or what's going on. Anyway, fingers crossed that we have class on Wednesday.
Yeah, I guess we just have to wait on Wednesday to see what happens.
Yeah, if he doesn't show up on Wednesday, I think I'm going to reach out. Yeah, I know we have a new chair and a new dean, but I'm going to reach out.
All right, then. Thank you, Amber.
You're welcome.
Okay. Any questions? All right. Anybody out there?
Yeah, I'm here.
Okay.
Yep.
Okay, thank you.
Yep.
All
We're here
right,
with you.
excellent. Glad to hear it. Anyway,
Hey, Larry, I do have one question.
yes.
I haven't had to test the discharge line for a sewer discharge pump
Yeah,
because I have to I have to do a call for inspection.
yeah.
Do I just do a running test on it?
I would call and talk to your inspector and see what they want.
Okay.
You might,
I haven't done it in a long time. I usually just test it with a running test. I never had it.
yeah, well, I would think that's probably okay, but who'd you get the pump from?
I bought it from Supply House.
Okay, I was gonna say, if you might give Barrett a call, they might have something to tell you about that, but normally I just call the building inspector and ask them what they want.
Okay, cool. Thank you.
Okay. Anyway, so in the law, and again, this is law, there are statutory exemptions. So some things are exempt. And so what these are is I don't know, but they talk about statutory exemptions. I see Olympic Games in here, family daycare homes.
Larry, you aren't sharing your screen
I'm
anymore.
not, gosh, dang.
Thank you.
Okay, you're welcome. No, thank you. Okay, can you see that now?
Yes.
Yes.
Okay, well, as I said, a couple of times, I will post this, but and you see that the ministerial projects are on here, emergency projects. So sometimes when I gotta go, you know, after a hurricane, a nuclear reactor meltdown, something like that, some things you just can't wait to take action on, and so those types of things are also exempt. So there's a fairly long list of things, but and then we have the categorical exemptions. And so in NEPA, I said these are called categorical exclusions, but CEQA, they use slightly different language. But you can see existing facilities, reconstruction, small structures, minor grading versus, you know, great big grading job. So minor land divisions. So otherwise, you're probably going to be subject to CEQA. And so there are a number of documents. Generally, you do an initial study. If you don't have a negative deck, you know, you can claim that there is nothing. If the agency agrees with you, fine. If they don't, then you're going to have to do at least an initial study. You can also have a mitigated negative declaration that basically says if we do certain things, that will make the problem go away, or at least mitigate the problem to an acceptable level. Environmental impact reports, which in NEPA are called environmental impact studies. And so those are public, and if you want to look at one of those, you can go online and they're posted all over the place. Just do environmental impact review and a whole bunch of them will pop up. So. So they talk about the questions to decide which document you have to provide, and there's something called the fair argument standard. An EIR is required if fair argument exists that a project may have a significant effect on the environment. And it says a fair argument must be backed by substantial evidence. Generally doesn't matter how much evidence supports the opposite conclusion of less than significant. So you only have to have a fair argument that there is going to be some impact to the environment. And normally you have to start moving forward with that environmental assessment. And so this is fairly inclusive or expansive, depending on how you want to look at it, because significant effect on the environment, they talk about potentially a substantial or potentially substantial adverse change in, says any of the physical conditions within the area affected by the project, including land, air, water, minerals, flora, fauna, ambient noise, objects of historic or aesthetic significance. And so, you know, particularly when it comes to things like aesthetic significance, that's highly personal and likely to change with time. And they say a social or economic change by itself shall not be considered a significant effect on the environment, although it could be.
Excuse me, Larry, do we have traffic as well?
Yeah, well, that would be a physical. Traffic is in there. So,
All right, thanks.
you know, just it talks about the physical conditions within the area affected by the project. And so these things are pretty broad, but certainly traffic could lead to changes in the air, could also impact flora and fauna, water. So there's a whole bunch of things there that it could. My sister, who's now retired, was a wildlife biologist for the state of Washington. And she was often called in to act as an expert on whether or not a particular project was going to have an adverse impact on animal life, for example. I don't know if you've been up, you know, on the way up to Valley Center from Escondido, or if you've been over the Scripps Bowway Parkway, either one of those.
Sure have, yes.
Yeah, okay, well, both of those have great big culverts underneath the highway projects that were put there to allow for the deer to cross without crossing across the highway. And then they have skylights or light wells built into them also. And I believe that both of those projects, they included some structures to house bats inside. And so those are all things that were not cheap. I think the animal crossings for the Valley Center project were about $750,000 a piece. And, you know, I've heard varying reports from people. Some people say the deer use them, and other people I've heard say the deer don't like to go into them because they don't feel comfortable going into these cave-like structures. They also provide a watering hole or a water trough of some sort at the end so the animals can get water. I worked on a project out in East County where we weren't allowed to do any soil compaction under the roadway because they thought there might be some historical artifacts from the Native American tribes that had been in the area. And so that created a bit of a challenge in terms of trying to build a stable roadway, but we finally figured it out. So then what is substantial evidence? And so it includes facts, reasonable assumptions based on facts, expert opinion based on facts, does not include argument, speculation, unsubstantiated opinion, or erroneous information. So I have seen, for example, out in the field where one archaeologist may come out to a site and say, see that pile of rock over there? And see that kind of those black marks on it? That's evidence of an old campfire. And then I've seen the developers, archaeologists, look at those and said, that's just a pile of blackened rocks. And that happened from a fire or something else, and doesn't look to me like it's man-made at all. So again, those opinions and assumptions may vary quite a bit from person to person. Again, they're talking about PRC, that's the Public Resources Code. And there's a statutory description there. So negative declaration, which is the ND, or the mitigated negative declaration. There's again a little flow chart here. You know, they prepare an initial study, distribute the notice of preparation. That's typically, there are time periods the agencies have to respond in. Normally 30 days is about the minimum. And so you can take a look through here, and if you have any questions, we can talk about them. But this is a time-consuming and expensive process, no matter which way you look at it. And again, the important part is the process is supposed to be transparent. There's a public review period. And you may see these advertised from time to time or get a notice. And during that period of time, these days, you normally send your comments into a website and they're recorded, and then all those questions or comments that they've received, whether they're positive or negative, are typically addressed. And they may refine that a little bit. So you see here where they say that public comments must be considered. No written response is necessary, but it is good practice. And if they don't want to be challenged in court, then they should come up with a good written response to any meaningful public comments. I don't know, do any of you deal with the public on a regular basis? Yay, nay?
Seldomly, but not too often.
Okay, well, the problem is, since these are public comments, anybody can say just about anything, and sometimes do. So sometimes it's a little difficult to respond to an incoherent or obviously out of reality comment regarding a particular project. So, but you're supposed to do some consideration of those things. So the EIR, you notice, is a longer process. And again, this is just trying to give you a timeline and a view of what's going on. But out here, you can see a public and agency review of draft EIR. So there's about 45 days in that. At some point, we get to the public hearings and a decision. And so the public hearings, a lot of times there'll be challenges as to whether or not the public received the proper form of notification and that the notification followed the proper timeline. So the agencies have to be very careful and make sure that they are responding to the statutory requirements with regards to these timelines. And you know what I often see with these is somebody will go through the review and they'll submit it to the agency, and the agency will take a look at it and they'll say, well, we're not going to design, we can't design the project for you. We're not going to design the project for you. But if it's a subdivision, for example, they'll say, we think the density is too high. Well, what would be acceptable? Well, we can't tell you exactly what we want, but we think that the density is too high and you shouldn't be maybe developing on some of these mountain ridges or something. And so that'll go back to the client and their planners, and they'll kind of redesign it and resubmit it. And then whoever's doing the review will look at it, well, you're getting a little closer here, but I still think there's some problems with it. You say, well, tell me what it is you want. Well, we can't tell you exactly what we want. It's your project, you have to design it. But these are the changes we think would make it a little bit better. And so by the time you're done, sometimes they have in fact designed it for you. But you identify the project, define it, develop some alternatives, and then it goes through a review, and you may get halfway through this. Remember, this process may take months or years, and so sometimes the people that are reviewing it, they may retire, they may die, they may get promoted, they may go to another job, and you may have to start all over with another person who may have very different ideas. So, and you can see the things that we're looking at for typical impact analysis issues. And the one that bothers me the most is always aesthetics. You know, because aesthetics are very personal, and when it comes to visual look, you know, there are some people that can't see it all. And so it's really very hard to, in my mind, deal with that on a completely objective plane. But agriculture and forestry resources, we're having a lot of issues right now with climate change, the forest fires, wildfires in California. So this is becoming an increasingly important issue. Air quality, which in many cases may be related to some of these other issues, transportation, wildfires. Supposedly the wildfires that have been going in Siberia for the last year have doubled the amount of carbon dioxide going into the environment, for example. Those fires in Siberia, bigger than all of the other wildfires in the world put together. So cultural resources, again, this is faddish to some extent. In California, for example, it's a felony to be in possession of Native American grave goods. You know, how old is our culture? If you've been to Europe or you Egypt or some places like that, they have cultural artifacts that may go back thousands of years. Here, very hard to find things that are much over a couple hundred years old at most in many areas. So depending on where you are, that can vary quite a bit. Energy, we're having big discussions about energy, renewable versus non-renewable. So if you've been watching television, for example, lately, I've noticed that the oil and gas industry has been lobbying very hard, promoting their particular industry, because right now it's under attack from a lot of different fronts, because when you burn fossil fuels, you release carbon dioxide and take that carbon that was sequestered in oil or coal, for example, and you burn it and then unsequester that carbon and release it into the atmosphere. And this summer, California's hottest summer on record. There definitely seems to be some changes. We did have an ice age. We've had a number of ice ages. We've also had a number of periods in the history of the Earth that were much hotter. But right now we're going through a very rapid change, which is unusual. And we're always seeing, also seeing a very large die-off in the number of different species of plants and animals that are out there. So, geology, soil seismicity. Here in California in particular, we have lots of earthquake faults. Some of those are active, many of those are inactive. Generally, a fault's considered to be active if it's moved within the last 11,000 years. Now, we have two major faults in the San Diego region that are considered active. We have the Rose Canyon Fault, which runs up Marina Boulevard and cuts through the gap over there on where the 52 is into La Jolla, and then goes offshore a little bit. And we have the Elsinore Fault, which parallels the San Andreas, but is just a little bit outside of Julian, a little bit to the east, northeast of Julian. And those two are both considered active. Soils, and again, soils, some soils are considered natural resources. So, you know, where you have a topsoil, most places in San Diego, we don't have a very thick topsoil. But if you've spent any time studying the Depression and the Dust Bowl years, that was a period of time when all the topsoil blew away. Farming practices were not great and caused huge migrations of people out of the Midwest, the Plains area. A lot of those folks came to California. Greenhouse gas emissions, which again, we are looking, state of California itself is committed to reducing the amount of carbon dioxide and other greenhouse gases that are being released to the atmosphere. Hazards and hazardous materials. So we're trying to find materials that are less harmful to the environment and the people. So lead and asbestos are two of the more common ones. Lead paint used up through the 90s even, that we were still using lead paint. Asbestos, they were still installing into the 80s and maybe into the 90s. But if you have a pre-1978 building, normally there's a presumption that it's likely to contain lead, it's likely to contain some asbestos. If you're doing a project along a major highway that's been around for a while, you may have concerns about what they refer to as ADL, aerially deposited lead. So it usually doesn't extend very deep into the soil, but at one time lead was a very common additive for gasoline and exhaust from the cars settled out. And so some places you have a very high levels of lead. Here in San Diego, it was almost all agricultural use. So most of San Diego has some background levels of DDT in the soil, and DDT component breakdowns. DDT will break down over time into other materials that aren't too healthy for you. So mineral resources. So I don't know how many of you know, at one time there was a small gold rush out in the Julian area. We have some tourmaline mines around here, but other parts of the state, they have other minerals they're considering. Noise, particularly if you're near an airport, near a railway, near a freeway, there are noise considerations. So affordable housing is another issue. You know, the whole issue of population and housing, public services and utilities. People need some form of recreation, transportation, and traffic. So these are all items that would typically be looked at in an impact analysis for a proposed project. So for example, you know, the largest extractive mining that goes on in California and in San Diego County is for sand and gravel. And most of the quarries and gravel pits have been closed. So we have a problem in that we have to import a lot of our sand and rock products from other places, even though once you get into the mountains of San Diego, it's almost all granite. Yet if you go to mine that granite, trying to open up a quarry, or what they refer to as a borrow pit, is a very long and involved process. I think we've closed well over 30 to 50 quarries and mining operations here in San Diego for the production of sand, gravel, and similar types of aggregate. I think we've only opened up one or two in the last 40 or 50 years. So if you want to retire young, find a way to open up a nearby source of gravel and sand, because we use tons and tons of it every day. So normally we have to, again, this just talks about the preparing the draft EIR. So that's the kind of the first go through. You have to look at the environmental setting and try and establish some sort of baseline. And so I know with stormwater here in San Diego that I've heard the water board talk about as a baseline for bacteria content, that they would like to go back to pre-Columbian days, meaning before Columbus discovered the New World. The only problem I have is I don't know how in the world you determine what the bacteria count in the natural environment was at that particular time. But anyway, we don't need to belay that. So determine significance criteria, evaluate the impacts, identify, recommend feasible mitigation measures for each impact. So on the left here, you can see some freeways. So again, when 30 years ago in San Diego, the air quality was pretty dirty. The freeways were a lot smaller. There was a lot less traffic. Has anybody bought gas lately?
Oh, yeah. Filled up
Yes.
yesterday.
Yeah, so it's it's a little expensive. I think I paid $100 to fill up one of the vehicles the other day. So if you ever get near one of the Costco's with a gas station, their gas is quite a bit less than most of the other places, but they usually have a huge line wrapped around the outside of their parking lot, even for people waiting to get in. But certainly these are the sorts of things that they're looking at. This looks like a chemical processing plant or maybe even a refinery here on the right. So with the refinery, certainly you would have a whole bunch of concerns about possible environmental contamination from the materials and also air quality issues. If this was in an area where it was kind of a pristine environment, there might also be some aesthetic concerns about the looks of all that industrial equipment. But how you quantify the impacts, there are lots of accepted procedures for doing that. Whether or not they're all correct or not, I don't know, but just going through that process, again, is very time consuming, very expensive, and you need to use consultants. And your consultants normally have to be approved by the government agency. So they have to have certain credentials in order for their opinions to be accepted.
$100 doesn't even fill up my tank.
Yeah, well, that's what I paid the other day too. So it gets a little painful.
I only got like 21 gallons.
Yeah, it depends on where you get it. I was someplace and I think it was down near the airport. It was over $5 a gallon. So anyway. What was I looking at there? We don't need to look at that. Oh, impact analysis. So you're looking at direct, indirect, growth inducing, cumulative effects. And so sometimes once you start to do development in an area, you put in a subdivision, for example, or you build a new road, and that may lead to a whole bunch more development. So when you're doing your EIRs, you're supposed to consider not only what you're proposing to do, but whether or not that has any leapfrog effects beyond the immediate effect. And you will have people arguing one way or the other. Part of the problem is whenever you try and predict the future, usually you don't do a very good job. So that's why things often go awry. Also, in addition to these direct and indirect impacts, usually we have intended consequences and we have unintended or unforeseen consequences for particular action. And that's just part of the human condition. And again, sometimes the experts, you're relying on expert opinions, and it is not unusual for expert opinions to not only be contradictory between different experts, but in some cases, the experts are not correct. And that's why the language in a lot of these things seems the same, is because, again, there are things that you can say and can't say from a legal standpoint. So they're talking about the substantial evidence being based on facts, reasonable assumptions based on facts. And so again, you're when you're making assumptions, right, you're exercising judgment. Expert, and you're saying that the substantial evidence does not include argument or speculation. Unsubstantiated opinion, erroneous information. NIMBY, everybody know what that is?
No.
That is not in my backyard. That is an acronym for not in my backyard. Because a lot of people would say, oh, I think, most of us, I think, are concerned about the homeless, but most people don't want a homeless shelter in their neighborhood. Because the real issue for many of us is that, we're concerned about sanitation and mental health issues not being addressed. But lots of people, if you buy a nice place out in the country, the last thing you probably want to see is a whole bunch of development down in front of you, because the reason you moved out to the country was so you could have that nice rural experience. So once you have yours, most people would prefer that others not have theirs, so they can truly savor the moment. Mitigation. So, what is mitigation? And again, to some degree, that is, based on opinion. It's supposed to be based on fact. In many cases, what's going to fix something, as things unfold, find out that what you thought was going to do the trick is not working at all. And so once the permits have been issued, the project hasn't been built, you're pretty much stuck with what you get. They normally can't go back and say, oh, now we need you to, we see that what we thought was okay in terms of mitigation is not okay. They can't then go back usually and make you redo the whole thing. Once you're given the green light with the conditions, you can move forward, satisfy those conditions, and walk away, whether or not you've actually taken care of things. So, if you're wiping out some rare tree, for example, I know on some of the county jobs, we cut down an oak, we may have to plant 4 more. But you're not going to take a 75-year-old oak tree, plant a baby oak, or go out and try and find a 75-year-old oak and move it. Is impractical. So they will usually come up with some formula for what they think is okay. When we built the La Bajada Bridge for the county, for every acre of wetlands that we impacted with the bridge structure, we had to put back or create 4 new acres of wetland because that's now considered to be a scarce resource. At one time, we tried to get rid of most of the wetlands because they were considered vectors for mosquitoes. So a wetland is basically a swamp or a slough of some sort. And so around the turn of the last century, early 1900s, we started draining all the swamps in order to deal with the disease problem. And the problem with that now is that a lot of wetlands or swamps we're very diverse from a biological standpoint, and we've lost a lot of animals that required that ecosystem to survive. Plants too. So there are also mitigation banks where sometimes the highest and best use for a piece of property is to keep it in a natural state. And that way, if somebody else wants to do a project somewhere else, they may be able to buy some undeveloped property, put that into a mitigation bank for safekeeping to offset what they're doing. Well, this is one area where some of the tribal bands here locally have a bit of an advantage because they have a lot of undeveloped, environmentally sensitive lands. Sometimes if you can't do any development on your property, one option to increase the value is to try and find a buyer who needs some of that land to offset some problem they're having elsewhere. Oh, we don't need to. So anyway, mitigation measures. Supposedly they're going to be in the public interest proportional to the negative impact. They need to be, whatever you're proposing to do needs to be feasible. So here they're talking about you're going to build 100 new homes. Part of the requirement might be to put in a tot lot. You might need to put in some traffic controls. You might need to build a storm drain system to protect the houses. Those are all things that could be done to mitigate potential problems. They're showing here that for 100 new homes, probably a new art museum would be appropriate due to the small nature of the development. If you were doing a great big master planned development where you had thousands of homes, then an art museum might be something that would be considered proportional to and appropriate as a mitigation measure. Do I want to talk about any of that stuff? No. I think I'll let you look at that. Okay. So let me get out of here. I'm getting tired of the EIR stuff. If you want to go more into that, we can, but this is a process we have to go through. So in California, as part of related to CEQA, in order to get the planning, we have to have the general plan. The general plan has to go through a CEQA review. And we have to plan our development for the future. And in the city of San Diego, the general plan has some specific elements. So all general plans are required to have, I believe it's 8 basic elements to them. And then they're allowed to have some other ones if they want. The city of San Diego's see this or not. Okay, can you see any of this?
Yes. Yes, I see it.
Okay.
Yep.
So again, this is the city of San Diego's general plan. And so the purpose of zoning is to implement the general plan in a specific way. The general plan is exactly that. Doesn't have specifics, it just gives some basic requirements. So the city of San Diego's general plan is currently comprised of 10 elements. And I expect they may be adding 1 or 2 more in the future. So we have this concept in the city of San Diego of a city of villages. And so that was dreamed up by the planning department and the former planning director who eventually went up to Los Angeles. But if you live in the city, you should know a little bit about this. And so we have a land use and community planning element, a mobility element, an urban design element, an economic prosperity element, and as you can see, they have it for various parts of the city. Kearny Mesa, Torrey Pines, Mira Mesa, Barrio Logan, Claremont Mesa. So, and this is where I'm expecting soon that they're going to have to modify some of this to deal with the current requirement for equity and environmental justice. Because certainly we have some wealthy areas that seem to get their way on a lot of projects. So in the county of San Diego, that's Rancho Santa Fe, seems to have undue influence. And they've got a lot of very wealthy people that live up there. And there are other parts of the county, Lincoln Acres, for example, down near National City, which has a much different demographic. And they don't have nearly as much influence in these planning decisions. So public facilities, services, and safety elements. And again, if you want to look on any of these, you can just click on it and you will see. So they got some neat little graphics, right? We got a little, looks like some sort of medical facility and trash. You know, the city of San Diego is a charter city, so that's why you do not pay for trash pickup. Because in the city charter, it says you won't be charged for trash pickup, but I know it costs money, so you're paying for it somewhere else. But if you are interested, I would encourage you to look at this. So this, you'll notice that different parts of the general plan have different dates on them, and because the updates vary, and they may not look at everything during a particular update.
So Larry, I have a question about that.
Yeah.
Does this also, I live in Ramona, so does this apply, is this all the same for unincorporated parts of the county?
Oh, yeah. Unincorporated parts of the county of San Diego has a general plan also. So if we look at and that's why it gets confusing. And so the county of San Diego, and they may have different elements. There are required elements under state law for the general plan, a minimum number of elements. And then the jurisdiction that oversees the subdivision of land, they can add additional elements. So you see They have slightly different names, but we have a land use element, a mobility element, conservation and open space element, housing element. Let's see, let me make that a little bigger so those of you that have a screen can see. And so if you look at the conservation open space, you can click on that and look at it, but it says addresses the conservation, development, and use of natural resources, including water, forests, soils, rivers, mineral deposits, and open space. The one that a lot of people are looking at is the housing element. The safety element, you notice we had a noise element, and here, see, this is a relatively new one, environmental justice element. I don't know what the date on this one is. But anyway, this is a new one, or relatively new, because this didn't exist a few years ago. But I think all general plans will probably have this environmental justice element in a relatively short time. So I think the first 8 they're required to have. And then we have, this is the newer one. And what it
Did you
says,
click on the discretionary permit cost guide?
where'd you see that?
It's on the right-hand side under popular services.
Oh yeah, just a second here.
It was down a little more.
Yeah, these things are pretty expensive, so. There it is, it's opening up now. Well, this is a little Excel spreadsheet, so let me just get a slightly different one. Okay, can you see this? Schedule of filing fees and deposits?
Yes.
Fee and the fee, you know how much it's gonna cost you. Deposit is exactly that. You pay a deposit for a particular service, and then the city or county charges against that deposit. And when they've spent all the money, they give you a call and say, hey, you got to send us more money if we're going to do any more work on it. Whereas with a fee, it doesn't matter how much work they do on it, they're just collecting the fee. And the problem is let me see if they've got the hourly on here. I don't see, somewhere they've got that hourly charge, but most of these are $150 to about $300 an hour that they're charging for these various types of fees. So just 1 second, so these are administrative permits. Generally, an administrative permit does not require a public hearing. And so some of these are much, this looks like an open space encroachment, for example. And so PDS is Planning and Development Services. LD is Land Development. DEH is Department of Environmental Health. And so if you need a SWQMP, that's a stormwater quality management plan. And so you want to do some agricultural clearing, which we'd have to look at the regulations to see where that's required. You know, it looks, I don't know, that must be a typo. Because the way they've got it, they've got that's a mistake. Let's find something that we know what it is. So if you needed to do a boundary adjustment, for example, that everybody know what a boundary adjustment is? You got two lots and you want to move the boundary between them a little bit. That's what a normal boundary adjustment would be. And so there is a $2,279 fee that you would have to pay for that. They say plus $95 for each additional lot or part of a lot. With a certificate of compliance means when you're done, they will have reviewed it to make sure that you have a legal lot when you're done with that adjustment. Without the certificate of compliance, you can see it's about $500 less. So Fish and Wildlife fees, talk about environmental impact reports. Since we were doing those, you got to pay $3,300 for somebody to review it. That's to the planning department. Negative declaration is still $2,400, which seems pretty substantial to me. Let's see what those little letters are. I can post this if you like. Oh yeah, the V means it's sometimes you have a violation fee. So that's what all these little acronyms down here. D is a deposit. And again, for a deposit, you don't know how much the review is really going to cost because they're charging against it. You're entitled to an accounting. But what sometimes happens is in most government agencies, planning departments, building departments, they're supposed to be charging against jobs. Most of them operate on what's called full recovery. And so they're supposed to account for their time and charge to specific projects. And so you as a client are entitled to an accounting of how they spent the money. Because if you see review charges on one of your projects, well, the project was not at the city or county, then you'd have a basis to say, hey, how could you be charging me at a time when nobody should have been working on the project? Because occasionally someone will either charge to the wrong number, which is pretty easy since all you got to do is transpose some numbers, and the charge is going to a different project, or in some cases, some people will be looking for a job that is big, that has lots of money in there, and they'll be charging against that. But these acronyms on the fees, whether it's a fee, time and materials, deposit. But this is why for a variance. So everybody know what a variance is?
Yeah, I actually got one for my septic tank.
Okay.
Yeah, so
Not exactly.
Okay, so generally variance, you've got a rule. So if you have you might apply for a setback variance. The required setback is 5 feet. You might have a unique situation where your lot is narrower than most of the other lots in the neighborhood. So the purpose of a variance is not to let you do something that other people can't do on their lot. A variance is to try and make it so you get roughly the same equivalent use of your lot or use that other people are allowed. So it's not to give you anything special. But when you file for a variance, again, they usually have major or minor ones. If it's something very minor, it can be handled administratively without a public hearing. If it's something more significant, then you probably have to notify all the property owners within 300 feet, and they'll have a public hearing. But you can see for a variance, there used to be about $1,000 at the county, but now they're up to $4,000, and they're showing this as a F or a fee. So at least you know what you're going to get paid. Or excuse me, I'm looking at the wrong thing, but on what people will call up and say, well, if I apply for a variance and pay the fee, is it going to be granted? And so the standard answer you're going to get is, if you don't pay the fee, you won't, there's no chance for it. If you do pay the fee, you may or may not be granted the variance, and that's how those things work. But minor deviations or less modifications. So there are tentative parcel map. So this is what we were talking about, a minor subdivision. 1970, $30 in 30 days. Standard application now for a minor subdivision, that's up to 4 lots with a remainder. You can see you start off with planning and land use for $12,000. You also gotta have, if there's a septic or well, there's a fee you have to pay to the health department. If there's a sewer connection, you gotta pay a fee for that. In some cases, depending on what the project is. So when you go to development, you're probably gonna be doing some sort of stormwater permit, but these are just for the, where are we? Yeah, here's our parcel map review. And so for your stormwater quality management plan, you got another $1,000, but you're gonna have to pay somebody a significant amount of money to prepare that for you also. So this process may take years. And if we look, what is that DLS? Yeah, so D is a deposit. And it says amount listed is intake deposit only. Additional deposits may be required. L, a landscape intake deposit or fee may apply. Then they talk you to refer to the landscape and irrigation plans case type for typical deposit. And then what was the other part up there? Yes, that's probably sewer. No, stormwater. Yeah, so the S then is the stormwater intake deposit may apply. But, that's a far cry from $30 in 30 days. And some of these things are quite a bit more expensive. I'll post that. You can take a look at. This is the counties. The cities will be different. And so you may propose a general plan amendment because if you want to rezone, for example, the first thing they look at is the proposed rezone consistent with the general plan? And if the proposed rezone is not consistent with the general plan, then what you would have to do in order to obtain a rezone is you would first have to amend the general plan. And again, that may or may not be possible, but you're going to have to spend some money doing that. And these fees are relatively minor compared to the fees you're going to have to pay professional land use planners or land use attorneys and the public hearings in terms of pushing these things through.
So Larry, in our local example here, both the Sierra Mesa and the Mission Valley developments, they have to, they pay for modifying the general plans.
Right.
Because they're just so massive that for the development, like for example, the golf course down in Mission Valley, right by the or not used to be, but it's like by the Town and Country. That's going to be a new housing development going in.
Right.
So that's so they had to revise the general plan for that.
Yeah, I'd have to go back and look and see what it was, but originally there was virtually nothing down there, and the golf course was really part of a flood
That was part of the flood control.
Yeah, it was built to mitigate the flood because it's in the floodplain and the floodway, and so part of that was designed to help deal with potential flooding in Mission Valley. Just as the stadium, if you look at the old stadium design, the stadium was up high. You had to park below the stadium all the way around. And the stadium was designed to be an island if there was a 100-year flood, so that it would still remain dry, but everything around it could get wet. And but that originally was never intended to have that level of development. But since the freeway's there, and as development patterns have changed in San Diego, all of that is indeed changing. Same with Grantville. They're planning on, I think, another 20,000 people in the Grantville area. And if you have been through there lately, they're building all these massive apartment projects in an area that formerly was primarily single-family residence and small retail operations. So, which, if you own property down there, I guess is good. So, I mean, I'm not sure what Kaiser's going to do with their facility down on Mission Gorge and Zion, because they've got to close that hospital because it doesn't meet the requirements anymore. But that, I'm sure, had a use permit for them to build that because it's right in the middle of a residential area. So what time is it? Oh, It's getting late. Let me stop one thing. Let me close this out. Let me get rid of that. So, there is one document I want you to read. I'm going to put it in Canvas. It's not there currently. We'll have some sort of in-class exercise I'll let you work on next time. Well, I think we're. So this is an assessor's parcel map page. I think we talked about those. Can you see it?
Yes.
Okay. So we can. Make that a little bigger. So up here in the upper right-hand corner, that's the book 404. That's the page 07. Up here, it looked like this is sheet 2. This is sheet 1. This has the zoning stamped on it. So in the old days, that's what you would have. Some places you'll still find something like this. And this is has the use regulations, animal regulations, and then the development regulations for that particular zone. So this was RS, which is single family residence. This is in the county. Also on the assessor's parcel page, you'll typically have a list of the changes. And so what this tells you is if somebody owns a parcel, over here on the far left, let me. Anyway, over here on the far left, this is parcel 5. If parcel 5 was to be subdivided into 2 new parcels, the 5 would go away and 2 new numbers would be assigned. So this little table over here on the far right that has the changes will tell you what happened. So in block 72, which is where this little oval is, block 72, old lots 1 and 2 became parcel 12. And so that looks like up here on this little finger that sticks up on the left-hand side, you can see kind of a trace of something. So I'm assuming this is the old lots 1 and 2. Probably went through what's called a lot consolidation, and they became a single parcel. And so that was done in 1977, and this is another document. 071, which is outside, and they talk about old lots 21 and 23 became lot 29. And so that looks like, here's 29 over here on the right. And again, I can see some, looks like some traces of what might have been old property lines, but those parcels became this new parcel. And we haven't talked about the lot consolidation or legal lot basis yet, but this is an assessor's parcel map. These days, you can normally call it up, and most of the jurisdictions, they can give you the zoning and the setbacks and all that other information, or you can send in an electronic request and they'll send that information out. Some things you're allowed to do by right on a parcel, and other things require special permission. So the document I'd like you to read is this one here. This is the counties. This is the zoning ordinance summary. There's about 12 sheets to it. This is that zoning box that you saw on that parcel map. And so we have different kinds of use regulations, animal regulations, which are pretty important in many areas. The development regulations, which include the density of development, the minimum lot size, building type, maximum floor area ratio or FAR, how tall they can be, although you have to look at the definition of height in the ordinance, how much of the lot you can cover, and then there's some setback requirements or open space. And then for some areas, you have special regulations. So the county zoning ordinance operates off of a matrix. So I would like you to read through this document. We will cover it briefly before diving into the, got to spend a little bit of time on the zoning itself before we get into building code. And so we have different setbacks in the building code than we do for zoning. But I'll give you a little exercise next time to go through. And here's the matrix. So this is the animal schedule. And so you'll have a designator in there. And if you see a little X, we have rows and columns. And where they intersect, if you see an X, that means it applies. And if it's blank, that means it doesn't apply. And animal enclosure setbacks. I used to get complaints on that. Normally, you know, if you have a horse or a pot-bellied pig, a cow, dogs, cats, whatever, if you keep them in an enclosure, most people don't want them too close to their property because of the smell and flies and other issues. But you know, there are zoning requirements, and if you're not in compliance, then they may call and file a complaint. Even if you are in compliance, they may still complain. So, but we will look at this next time. I apologize for talking way too much tonight. I hope everybody has a pleasant evening. But I will post this in the Canvas, and then I'd like you to read through it, and we'll go through an exercise. If you want, you can look up your own zoning. And if you have any questions, if anybody here is fighting with codes enforcement or zoning enforcement or some other kind of enforcement related to land use, feel free to bring that in and we can talk about it.
Cool.
Thank you.
Okay, well, thank you. Let you go. Hopefully it should be cooler next week.
Thank you.
Good night, everybody. Thanks very much.
All right, good night.
Night.
Have a good night.
Thank you.
Thank you.
Bye, Larry.
Thank you.
Good night.
Good night.
All right, thank you. Good night.
Okay. I'll turn the video off, but I'll leave the microphone on.
Thank you, Larry. Have a good night.
Okay, you too.
Don't forget to stop recording.
Oh, yes, thank you.